Good afternoon. My name is Steve Drizin, and I'm a clinical professor of law at Northwestern University's Pritzker School of Law in Chicago. I'm also the co-director of the law school's Center on Wrongful Convictions. And today I'm going to talk to you about juvenile coerced and false confessions. I'm going to do this lecture in three parts. The first part is going to talk to you generally about the problem of false confessions. It's going to give you some numbers, some data about just how prevalent they are, and overview of the causes of false confessions. The second part is going to focus on the tactics that police officers use in order to persuade someone to confess to a crime. Sometimes they are so powerful that they can cause somebody to confess to a crime that the person didn't commit. And finally, we're going to see these tactics in action in a real life case. The case of my client, Brendan Dassey, who was the subject of Netflix Making a Murderer docuseries. So let's begin with the very end of Brendan Dassey's interrogation. Now, Brendan is a 16-year-old boy with severe learning disabilities, and he has just been interrogated for more than 3 hours outside the presence of a parent or a lawyer or a guardian. And police officers have persuaded him to confess to the murder and rape of a 24-year-old photographer. And when his mother comes in the room for the first time, she says to him, "Brendan, did you confess to this crime? Did you really do it?" And Brendan has to explain to her why he confessed to a crime that he didn't really do. And let's hear that.
Did you? Huh?
Not really.
What do you mean, not really?
They got to my head.
Huh?
They got to my head is the best that this 16-year-old learning disabled kid can come up with to explain the psychological process that caused him to confess to a crime he didn't commit. And what we're going to do today is we're going to explore what that means, exactly how police officers get into suspects' heads, even innocent suspects, to persuade them to confess to crimes they didn't commit. But let's start with an overview of exonerations based on false confessions. And here's what we know. We know that according to the Innocence Project, which has an extensive database of DNA exoneration cases, that false confessions are involved in approximately 27% of all of the DNA exonerations to date. It's one of the leading causes of wrongful convictions. And I think that when the Innocence Project began in the early 1990s, this was perhaps the most counterintuitive of all of the findings. The idea that such a substantial portion of wrongful convictions are based on false confessions. The National Registry of Exonerations, which is a bigger database that includes both DNA exonerations and non-DNA exonerations, pegs the number at approximately 12% of their 2,674 exonerations. So we're talking about a substantial number of innocent people confessing to crimes they didn't commit. Everybody in these databases have been exonerated, which means that their convictions have been overturned based on newly developed evidence of actual innocence. But there are many, many other false confessions that never lead to convictions because they are discovered, often through the use of DNA testing, before trial, before a wrongful arrest can ripen into a wrongful conviction. let's talk about some realities and myths. And let's talk about the young man who's featured here. This is Marty Tankleff. And Marty Tankleff, like many of you, was a high school senior. He was getting ready to begin his senior year. And on the morning he was about to go to school, he woke up to the worst imaginable nightmare. He found both of his parents had been murdered. Actually, his mother had been murdered and his father was clinging to life. The police officers called 911. They came to the scene. And as is usually the case when there are crimes involving the murder of loved ones, they focused their attention on Marty, on people who were living in the house at the time of the crime. And they took Marty back to the interrogation room and they grilled him for 5 hours. And at the end of that 5 hours, during which the police officers faked a phone call, one of them claimed that he had just gotten a telephone call from the hospital in which the doctors had administered adrenaline to his father, and that his father had woken up from a comatose state and said that Marty was the one who stabbed him. That lie broke Marty down and caused him to confess to murdering both of his parents. And he described this process, he described it as like having an 18-wheeler driving on your chest. And you believe that the only way to get that weight off your chest is to tell the police whatever they want to hear, even if it's admitting to a murder. Now, in murder cases, false confessions are the most common cause of wrongful convictions. Usually it's mistaken eyewitness identification. But when the Innocence Project looked closer at the numbers, in cases involving murder cases only, approximately 62% of them involved false confessions, whereas only 31% involved eyewitness misidentifications. And that's because homicide interrogators are the most skilled in using the kinds of psychologically coercive techniques that produce false confessions. Now, it's often not easy to tell when you're looking at a videotape of a confession whether that confession is true or false, because many false confessions are extremely detailed and they appear plausible. And if an innocent person is confessing, how does he know or she know so many details of the crime? We'll talk about that process called contamination later in this presentation. Something that surprised me when I got started in this work is you often see multiple false confessions in the same case, meaning multiple defendants who end up being charged with the same crime all confess and they're all false. You've probably heard of the Central Park 5 case, but that's just one of many, including the Norfolk 4, the Englewood 4, the Dixmoor 5, the Beatrice 6, and the granddaddy of them all, the Uptown 7, which involved a case of 7 boys who falsely confessed to murder in Chicago's Uptown neighborhood. False confessions also often lead to false guilty pleas because many attorneys, in looking at their cases, see that their client has confessed and persuade their clients to plead guilty to these crimes that they often didn't commit. It's not obvious when a confession is false, and it's not true that you would only confess if someone beat you. That is a common misconception, that only confessions are false if they are the product of police abuse or torture. While juveniles and intellectually disabled are more likely to falsely confess when pressured by police, they by no means represent the entire universe of people who falsely confess. What I aim to do today is to convince you that even you would confess to a crime you didn't commit if placed in the pressure cooker of an interrogation room. Confession evidence is so powerful that if it does get entered into evidence at trial, we know that 81% of innocent defendants will get convicted. And that's because juries often don't understand the psychology of false confessions. After today, I hope you'll understand it a little better. One of the things that is amazing about false confessions is that even DNA evidence, the most powerful evidence in a court of law, or let's say the most accurate and certain evidence in a court of law, if it goes face to face with a confession, meaning that if the DNA evidence proves that the person who confessed didn't actually commit the crime, juries will still convict these defendants in many of these cases. It's just that powerful. And jurors have such a hard time thinking that they would never confess that they're willing to discount science on the way to convicting innocent people. Now let's talk about juveniles. By juveniles, I'm talking about people under the age of 18. We could go higher because new developments in adolescent brain science tell us that the inner workings of our brains are still maturing up through the early 20s. But let's just focus on those under the age of 18. We know that they are much more likely to falsely confess when pressured by the police. We know that by looking at laboratory studies, which create scenarios where students are accused of crashing a computer by hitting the wrong key when inputting data. Even though it's false, these students confess. They pick up a pen and they sign a confession admitting to crashing the computer, with hardly a second thought. We know that if you look at actual cases of false confessions, at least a third of them involve children under the age of 18. And we know from one large study that 3 times as many juveniles falsely confessed as adults. And as you might expect, the younger the juvenile, the more vulnerable the child is to falsely confessing. Now we're going to talk about the adolescent brain, just briefly, and why it makes juveniles particularly vulnerable to police pressure. The area of your brain right behind your forehead, it's called the prefrontal cortex. It is the area that governs judgment and decision-making, the weighing of risks. And that area is the very last part of a teenager's brain to develop, meaning that throughout most of your teenage years, you're ruled by other parts of the brain that are more sort of impulsive. They are more based in the regions of your brain that govern flight or fear, and your decision-making is more rash. But you need a fully developed frontal cortex in order to be able to withstand the rigors of police interrogation, which are all about weighing and assessing risks. They're all about, they focus on making you think about the immediate rewards that are come to you from confessing, one of which is that the interrogation will come to an end, versus thinking about the long-term consequences. What am I really doing to myself by confessing? And there's also a lot of evidence to suggest that teenagers are much more vulnerable to external influences, including pressure applied by both peers and adults. Now, for years, the United States Supreme Court understood this about teenagers, and they understood it particularly in the area of the law that governs the admissibility of confessions. Way back in 1948, in the case of Haley versus Ohio, the court wrote that interrogation tactics which would leave a man cold and unimpressed can overawe and overwhelm a lad in his early teens. That message that the same tactics, when applied on teenagers, create much more havoc than they would with adults, kind of has gotten lost over the years until recently. In 1962, the court said the same thing in different words, that a 14-year-old boy, no matter how sophisticated, is unlikely to have any conception of what will confront him when he is made accessible only to the police. And they'll likely have even less of a conception of what might happen to them if they confess. And in 1967, the court said that we have serious doubt of the reliability and trustworthiness of juvenile confessions. In this 1967 case of In re Galt, Justice Fortas really explained the basic reason why suspects falsely confessed. Is suspects are placed in a situation where the risks associated with falsely confessing are less than those associated with maintaining one's innocence. Falsely confessing becomes the more promising of two alternatives between which the suspect is required to choose. One of those alternatives has horrific consequences. The other one has less severe consequences. And those are the only choices that interrogators will give a suspect. And under those circumstances, children and a lot of adults are going to choose the lesser of two evils. So since 1967, between say 1967 and the year 2011, the Supreme Court and courts throughout this country really drew no distinctions between the way that they evaluated juvenile confessions and the way that they evaluated adult confessions. It was as if those old cases had been written off the books. But the discovery of large numbers of false confessions through organizations like the Center on Wrongful Convictions, where I work, and the Innocence Project, and what are now more than 50 innocence projects around the country, has caused the court to take a second look at these cases involving juveniles. And recently, at least in 2011, the court held, in the case of JDB versus North Carolina, that the pressure of custodial interrogation is so immense that it can induce a frighteningly high percentage of people to confess to crimes they never committed. That risk is all the more troubling, and recent studies suggest all the more acute when the subject of custodial interrogation is a juvenile. We'll have to wait and see just how much lawyers and suspects can use this new language to get their confessions thrown out of court. But the Supreme Court's recognition is not the only place where juvenile vulnerability has been recognized. Even leading police authorities, the trainer of police officers on how to interrogate, have recognized this. The leading interrogation training outfit in the United States is an organization called John Reed and Associates. And they have written that extreme care must be used when questioning juveniles. And the investigator has to modify their approach with these individuals. Don't question kids the same way you question adults, because when you do, it's a recipe for a false confession. The International Association of Police, Chiefs of Police, has also weighed in and has suggested using different and more appropriate interrogation tactics that reflect the differences between adults and teenagers. But while police officers, or at least organizations that work with police officers, acknowledge these differences, officers in the field often do not apply them in the interrogation room. And why is that the case? We'll talk about that. But in particular, one of the ways in which Reed and Associates tells investigators to change their tactics is they should use extreme caution and care when interrogating juveniles, but they should also limit the use of tactics which are perfectly legal, but particularly problematic if you're a juvenile in the box. Police officers are allowed to lie to suspects about evidence, and Reed counsels them against that. But why are police officers taking heed of these lessons? It's interesting. In the largest single survey of law enforcement officers, these police officers understood the issues. They agreed that adolescents and children have reduced comprehension abilities. They are highly suggestible, and that, oftentimes the kinds of things that you look for in terms of body language from a suspect to see whether or not they're lying, they're not really reliable in kids who frequently slouch and don't look adults in the eye. But when you ask these same officers whether they make any concessions to these understandings about kids when interrogating them, they frequently said no. The majority believed that both children and adolescents understand what was happening during the interrogation, that they were not any more suggestible in the interrogation room than adults, and that they could detect deception in children just as easily as they could in adults. So some specific tactics that we see again and again in interrogations that lead to false confessions. One of them is you're not supposed to use promises or suggestions of help. And we'll see this when we look at Brendan Dassey's interrogation. Because when you say that you are there to help somebody, or that the goal of the interrogation is to get them the help that they need, that sends a message of leniency, a message that punishment is not what's going to happen then to the children. And so that becomes a promise of leniency that we see in many false confessions. And again, there's a real problem with using deception with juveniles who not only don't believe or understand that police officers can lie to them, but they are naturally deferential to adult authority figures. And that doesn't matter whether you're a high school senior at one of the best, most academic high schools in the country, or you're a street smart kid who has grown up in neighborhoods where police officers have aggressively policed people in those neighborhoods. When you're in that interrogation room, when you're on the home turf of a police officer, when you're isolated, the interrogator has all the advantages. One way we learn about juveniles and false confessions is that we ask our clients, what was it like in that interrogation room? And this is what some of them said. This is Calvin Owens, who at the age of 14 falsely confessed to the murder and rape of a medical school student from the University of Illinois in Chicago. I thought I was going home. I didn't understand the seriousness of what was going on. I didn't understand exactly what I was getting myself into when I signed that statement. This is 12-year-old Jonathan Adams. I thought if I just told them something, they'd let me go home. And my client, Terrell Swift, age 17, never been in trouble with law enforcement before, becomes the subject of a murder investigation of a prostitute in his neighborhood. I had the perception that the police were there to help. I signed a confession under the pretense that I was going to go home later that night, but it didn't work out that way. He spent nearly 2 decades in prison before DNA exonerated him. And again, here are a couple more quotes. My client, Robert Taylor, being interrogated felt like I was choking, like there was no more air left in the room. It was psychological intimidation and mental. I mean, I was a kid. I was 17. I was vulnerable and I didn't know. I had the perception that the police were there to help. And in my case, I feel they took advantage of me being a youth and being naive. Let's take a pause here before we move on to the next part of this interview, this lecture, so that we can take a break before we talk about interrogation tactics in particular. So those of us who study false confessions have determined that there are 3 errors that occur in each interrogation that leads to a false confession. And the first error is what's called the misclassification error. Basically, that means is that the police officers, for whatever reason, believe that the person they are questioning is guilty. You don't interrogate innocent people. You only interrogate people who you have a reasonable suspicion of having committed the crime. You interview people who may be innocent. And an interview and an interrogation are 2 different things. An interview is an information-seeking, open-ended kind of questioning during which a conversation occurs where you get basic information from the suspect. There's very little stress involved in the interaction. It's an opportunity for the suspect to tell his side of the story, what he was doing on the day that the crime occurred. And it's relatively low stress. I mean, both interviews and interrogations take place in rooms that are separate and apart from other parts of the police station. They tend to be small, cramped rooms. There's no table, usually only a few chairs, because a table can prevent the interrogator from invading the suspect's personal space. The door is almost always closed. There are no clocks or other distractions on the wall because they are distractions from the business at hand, which in an interrogation is to get a confession. So the interrogation is much more accusatorial. It is a police-dominated encounter that is guilt presumptive. And you'll see that in some of the videos and audio clips that I'm going to show you. The misclassification error, let's talk about that. When police officers go to training, when they become interrogators, and they go to the police academy or they hire outside experts to come in and train them, police officers believe that they are human lie detectors, that they can determine just by looking at you and assessing your body language or listening to you and assessing the kinds of words that you use in response to their questions, that they can tell whether you're telling the truth or not. They can read signs of deception. And here are a couple examples of some material from the training materials of some of the leading interrogation firms in the country. And this is again from John Reed and Associates. Who's a truthful individual? Well, composed, concerned, cooperative, direct and spontaneous, sincere or open. What about how do they look during an interview? Well, they have smooth posture changes. They have open gestures. They have good eye-to-eye contact. They maintain a frontal alignment, meaning that they are faced squarely at you and not turned in any way or have a barriered posture. They lean forward and they seem eager and ready to answer your questions. The deceptive individual is somebody who is overly anxious, as if being interrogated by a police officer by yourself in a room isn't anxiety producing in and of itself. They're defensive, unconcerned, evasive, too polite. You can be too nice. And they're guarded. And from a body language standpoint, you see a lot of posture changes that are erratic. You see slouched, overly casual behavior. And you see hands over your mouth or over your eyes, barriered postures. That's what they are trained. And during the interview section, police officers are assessing you to see whether or not you're lying to them or not. And they are so confident in their ability to detect deception that if they think you're lying to them, then they think you must be guilty of the crime that they're going to question you about. And part of what drives an interview into an interrogation is this belief in their abilities as human lie detectors. And there are even different kinds of phrasing that they are taught indicate truthful responses or deceptive responses. So any qualifying phrases like, I honestly would do that. Any appeals to religiosity or to God or to, I swear on the Bible that I didn't do that. All of that are signs, according to police, of being deceptive. What somebody who is much more direct, I did not rob anybody, I did not rape her, those are the kinds of denials that ring true to police officers. But ask yourself, how reliable is this kind of body language? And let's look at Brendan Dassey and take a look at how he would look to police officers. Well, look at him. He's slouching. He's got a barriered posture. He's got his hand in front of his face. He's not making eye contact. He's giving off all the signs of someone who, in the eyes of police officers, is being deceptive. See, police officers, they don't do an investigation really into the makeup of the person they are interviewing. And many people, like Brendan, who are learning disabled, who have attention deficit disorders, or teenagers, are going to exhibit signs that are easily mistaken for deception when they could very easily be anxiety-based or personality-based. So we know, for example, from looking at Brendan's school records, that from as early as third grade, he can't look an adult in the eye. He's uncomfortable looking adults in the eye. He's withdrawn. He doesn't function well with others. He's been in special education classes since grade school, and he has trouble understanding basic vocabulary both to and from him. He's particularly has a hard time with understanding what certain idioms mean, like the truth will set you free. He doesn't know what that means. He actually thinks it means it's going to allow him to get up and walk out of the interrogation room. Over and over again, his learning disabilities have been diagnosed, and over again, when these interrogators questioned him, they did so in a way that took advantage of his learning disabilities. When police officers are trained in these body language and nonverbal and verbal indicia of deception, they're also told that there's an 85% accuracy rate in their ability to detect deception. And there's no science at all that proves this is the case. In fact, study after study after study demonstrates that you and I are really no better than a coin flip at detecting deception among people. Many signs that we think indicate deception can be as a result of cultural differences between us and the person who we're talking to, or they could be, a result of anxiety. But it often leads police officers to move from an interview to an interrogation. Other things that cause them to suspect innocent people include things that are part of their experience as police officers. But again, hunch and experience are not evidence. They may increase the odds that the person you're interviewing might be guilty, but they're not evidence of guilt. And when you play the odds, you often get it wrong. Crimes committed upon children must have been committed by parents. Parents are always the suspects when children go missing or children are killed in household incidents. And they should be persons of interest. But again, there's a difference between a person of interest and a suspect. And police officers often run right by that distinction. If someone is killed in the home and there are no signs of forced entry, police officers always assume that the crime must have been committed by someone who was in the home. But today's burglars can get in and out of houses without leaving signs of forced entry. And many times people leave windows or doors ajar that they thought were locked. So again, error comes into play when police officers jump to a conclusion based upon no signs of forced entry. In Chicago, there's a presumption in many neighborhoods that crimes that are committed in these neighborhoods must be gang-related. And we see confessions that have these detailed descriptions of gangs, and then we learn later that the crime was committed by a single adult male sexual predator and had nothing to do with gangs. The last person to see the victim alive must have been the one that killed her. The person making the 911 call is a prime suspect. These are things that give police officers a reason to question you, but they're not evidence. And the problem with most false confessions is that the theories that police officers are pursuing with a suspect are not based in evidence. Now, how do police officers manipulate children and adults in order to get them to confess? How do they do that with innocent people? And this really goes to the heart of interrogation. You have to understand just how stressful it is to be in the box and to be questioned by a homicide investigator who is hell-bent on getting you to confess, who thinks that you are guilty, and who is not going to take no for an answer. These techniques can be deceptive, they can be manipulative. Anytime the suspect asserts his or her innocence, police officers are trained to cut that off. We're not here to decide whether you committed the crime. We already know that. We're here to decide why you committed the crime, because why you committed the crime may enable us to help you, depending upon your answer. These tactics are highly psychologically coercive because they imply leniency if a suspect chooses answer A, and they threaten harm if a suspect chooses answer B. The suspect is given two choices. Either you committed this crime deliberately and premeditated, or it was just something that you snapped, you acted impulsively. You didn't mean to kill that victim, or the victim may have led you on or provoked you in some way. I don't think you planned this out in advance. I don't see you as a cold soul versus someone who committed a crime of passion. These kinds of distinctions, these choices, both of which make the suspect guilty, but one of which makes them, gives them a face-saving excuse, ultimately give the suspect with two choices. And most suspects, both the guilty suspect and the innocent suspect, over time will choose either A or B. So here's one tactic that we see oftentimes when children are in the box. Everybody knows that there's juvie court and there's criminal court, and that in juvie court, you're not going to be punished as hard as you are in criminal court. And most kids know where the juvenile court is in their various jurisdictions, and many of them also know that what happens in juvenile court stays in juvenile court, doesn't become a part of your permanent record. And police officers in the midst of an interrogation will often play off of that. Listen to how it's done in this case.
So you have two ways you can deal with this. You can deal with this in juvenile court, where they're going to tap you on the wrist and send you on your way, or I can hold charges out until you turn 17 years old. Then I'm not just going to charge you with the robbery, I'm going to charge you with kidnapping as well.
Where would you rather be? In juvenile court, where you get a slap on the wrist, or in criminal court, where you're looking at serious time for a crime? Here's another example of that.
Well, Detective Doherty told you, you're still a juvenile. We can help you. We can get you help. Your first thing you have to do is admit you have a problem. If this drags out, then we'll push to try you as an adult. I don't really care. I told your mother I don't care about her, and I don't care about you. I care about that baby. More than your mother, by the way, because she didn't shed one tear. Not one tear in 3 hours. And we're the only voice that baby has right now.
The false evidence ploy is a tactic that police officers use. This is the deception that we're talking about that is so powerful that it often is one of the first steps in the road down to a false confession. The first error was the misclassification error. The second error is the coercion error. And the power of the false evidence ploy is at play in almost every false confession. So what does that mean? Well, it means that police officers can lie to you about the evidence that they have. They often come in with a big file, thick file, with the words murder written on it. It's filled with papers. And they refer to this file as all the evidence that they've gathered against you by speaking to witnesses, by getting lab results, that this is the evidence that we have against you. It could be a file filled with Chinese takeout menus, for all you know, but it's used as a prop to make it seem that the case against you is rock solid. Now, it can be specific. It can be, we found your fingerprints at the crime scene, we found your DNA, or we're doing DNA testing and I know it's going to come back to you, or your compadre in the room next door is telling us that you were the one who did the killing, and that he was just a witness. Do you want to be the witness or the perpetrator? Because I don't believe him. I think you were only the witness. You know, these kinds of lies bring a suspect down to hopelessness and make it easier for police officers to manipulate you into falsely confessing. These are at play in almost every documented police-induced false confession. And police officers are allowed to lie because the US Supreme Court in 1969 said that the mere fact that a police officer lies to a suspect is not enough to render that suspect's confession inadmissible. We have to allow police officers to lie, the court said. They need sometimes to get down on the same low moral plane that suspects are on in order to be able to get the truth. You get that? We need to let them lie so that they can get the truth. But when police officers lie to children, oftentimes they don't get the truth. They get another lie. Here's a great example of a false evidence ploy in the case of a client of ours named Robert Davis. Robert Davis was a suspect in the murder of a woman and her small child. The woman was stabbed to death and the child died as a result of smoke inhalation when a fire was set to cover up the crime. And during the course of this interrogation, this is what the interrogator said to Robert. Robert is 18 years of age when this interrogation.
Don't turn around. No, just face that way for me. And then if you would, do the same thing with your other hand. Take 2 steps forward and you put your hands down at your side.
Do you know your skin is the worst thing in the world as far as dust? You can't even see it. Dust is made of most of human thin skin. That can be picked up, that DNA. That stuff right there, if you touch anything, the glove part will be picked up and match with the shirt. The same thing with the gloves. I can match it to the exact level you wore. Where? What you wore? You were there. The evidence shows you were there. The evidence shows you. I can't lie about the evidence.
I can't lie about the evidence. I mean, that plays right into a youthful suspect's belief that police officers aren't going to lie to them. They're not allowed to lie to them. You know, it's against policy or against the law for them to lie to them. But that's a lie in and of itself. And now we come to the final error, the contamination error. Once a suspect is so hopeless that they choose one of the options given to them by the police officer that renders them involved in the crime, present at the crime scene, it's somehow guilty of the crime. The interrogation is not over because every good police officer knows that the devil is in the details, that the only way a confession is going to be determined to be reliable is if it contains information that only the true perpetrator would know or that police know. And in the best of circumstances, if the suspect can lead police officers to evidence that they haven't even uncovered yet, the murder weapon, the bloody clothes, the fruits of the robbery, whatever it is. If a suspect can do that, he's probably guilty. And the contamination error explains why so many false confessions appear to be reliable. They're filled with the kind of details that you would think only the true confessor would give. How does that happen? Let's talk about Neil Nelson. Neil Nelson is was a commander at the St. Paul, Minnesota Police Department. He was a trainer of trainers and taught many people how to interrogate suspects. And he took a false confession from a 13-year-old to the murder of his father. It was a kid who was camping with his father, and went to sleep in separate tents. He woke up the next morning, he found his dad beaten to death with a log. And because it was in the wilderness and because there were no other people there, Nelson thought this kid must have done it. And so he grilled him. And as he was preparing for trial, after the kid confessed, he said, after I looked at this recorded interrogation, you know what I found out? I realized that I gave him those details. I gave him too much detail as I tried to encourage him, and he just spit it back. The single biggest source of contamination is the police spoon-feeding the facts that make a confession reliable in their questions. It's often done by leading questions, or it's often done by showing a suspect crime scene photos, which contained tons of information, what the victim was wearing, what kind of wounds the victim suffered, where the crime occurred, whether the victim had a tattoo or jewelry. This kind of information that gives a story the ring of credibility is often shown by crime scene photos. And even in the Central Park jogger case, police officers took the suspect back to the crime scene. The suspects in that case all described how this assault on the jogger took place miles away from where she was actually assaulted, down by the reservoir in New York Central Park. But when police officers took them to the actual place of the assault on 106th Street in a pathway that crossed the park from east to west, they gave them details that they couldn't provide themselves. And unless you record the entire process from start to finish, it's very difficult to see and to find evidence of contamination. Here's a great example of contamination from Robert Davis's case. Now, the police officers in this case knew that the victim had been stabbed and beaten before the house was set on fire. But Robert had no idea what happened to her. He had never been in that house in his life. And see how the interrogators manipulate him.
Around. Just face that way for me. And then if you would, do the same thing with your other hand forward and put your hands down at your side.
What can I say that I did to get me out of this? I held her down when they tied her up. Yeah. And then I hit her 2 times. Because they said if I didn't, it would be... Wait a minute, I got somebody else clubbing her, Robert. I got someone else doing that act. You did another act. You know what that act is. And we know. And that's the thing that has something on it that's yours. All right? Robert, I'm going to come straight out and tell you what I'm getting. All right? Since you're not going to tell me. All right? You did another act. All right? You did another act to that lady. And you can sit here and say, I got 3 other stories telling me what you did. And why you keep not wanting to say it, because either way, clubbing or doing the other act are the same thing. Except the fact you know exactly what I'm talking about. I don't know exactly what you're talking about. Did you, and I'm going to ask you, I'm going to bring it out as a question, but I know the answer. Did you or did you not stab that woman? No. I was lying to you about that. I did not stab her. I had the knife, though, and I don't know if it stabbed her or not, but I didn't stab her. If I did, I didn't mean to. You know what you did, and you stabbed that woman. I stabbed her.
So those are 3.
Really going on one limb here with you. Would it make you feel better if we told you exactly who was with you? Yes, it would, because I can tell you. If I'm not hanging out with you, I can tell you that I would not hang out with these people because I don't want to. But you know that kind of defeats the purpose, though, right? Yeah. I mean, you understand that? Is whenever we have to start telling you what you already know. But if that helps you, maybe we can do that.
So police officers know that they're not supposed to do that. In fact, I have a theory that the interrogator in Robert's interrogation was being watched through some two-way glass, or his interrogation was being monitored on video. And when that interrogator says, "I'm going to just tell you, did you stab that woman?" He got beeped by his supervisor, because that is the cardinal sin of interrogation, because the end result is the confession is not really the suspect's confession. It's the police officer's confession that conforms with a preconceived theory that they have about how the crime occurred. Let's take a break, and then let's go into Brendan Dassey's case. And I'll start out with a description of the facts of the crime. And if you haven't seen Making a Murderer, it's on Netflix, you should check it out. But we're going to focus only on Brendan's part of the case. This is Brendan Dassey. I met Brendan Dassey in 2007 when he was 17 years old, about a year after he had been convicted of first-degree murder and sexual assault and sentenced to life in prison, with no possibility of parole until he had served at least 41 years. And when I met Brendan, the case against him was built almost exclusively on a confession. And thankfully, that confession was electronically recorded from start to finish. So, the case against Brendan is pretty much confined to what's on that videotape. And that videotape has been studied and dissected over and over again, because there are many things that police officers did during that interview that, even seasoned interrogators find offensive. And we'll talk about the way in which Brendan was broken down into giving a confession. So here's a little background. On October 31st, Halloween Eve, 2005, Teresa Halbach, a 23-year-old photographer, went missing. And she was not reported missing for several days. Her last appointment before she went missing was at a place called the Avery Salvage Yard in Wisconsin, in rural Wisconsin, outside of Manitowoc, Wisconsin. And it was a sprawling salvage yard. When I visited it, I had never seen a junkyard that big, filled with all these hulks of cars that had been sort of hollowed out for parts and then, slowly taken to a crusher and melted. At that salvage yard, which was the last place that Teresa was known to visit, she was there to take photographs of a van for a magazine. The van was up for sale. Lived a man named Stephen Avery. And Stephen Avery had sort of a checkered history in the state of Wisconsin. He had been arrested and convicted of a rape in 2000, he had been convicted of a rape in 1985. And he became the first DNA exoneree in Wisconsin. DNA testing proved not only that he didn't commit the crime, but it proved that another man, Gregory Allen, had committed this rape. And so when he came out of prison, there was great pomp and a lot of fanfare and front page news in all throughout Wisconsin. And, even in the New York Times, there were stories about Avery because it was the first DNA exoneration in Wisconsin. And then Stephen brought a $36 million lawsuit against the police officers who had, railroaded him in this original rape case. He had spent 18 years in prison for a rape he didn't commit. And so here was this person who came out, politicians were taking pictures with him, everybody wanted a piece of him. He testified in front of the General Assembly. He sat on committees to try to figure out what went wrong in his case and others. He had a task force named after him by the legislature. He was the toast of the town, and Teresa Halbach disappeared on his property, and he was present on the property at the time she disappeared. So the authorities closed off the property. They did an extensive search of the property for 8 days, and they found evidence that Teresa was the victim of foul play. Her car was found in a secluded area of the property. Her car key was found in Stephen Avery's trailer. Her blood was found in the back of her car, and there was evidence that Avery was involved in her crime because his blood was also found in her car. His DNA was also found on the hood latch of her car, and somebody had opened up the hood and disconnected the battery from its battery cables for some reason, and they found his DNA on that hood latch. And the most gruesome discovery of all is they found Teresa's bones located in a burn pit that was adjacent to Stephen's home. So police officers strongly suspected that Stephen had killed her, probably sexually assaulted her, and then disposed of her remains in this fire pit. Now, Brendan was Stephen's 16-year-old nephew. He wasn't even born when Stephen went into prison, and really didn't have much of a relationship with him until after he was released. And then the two of them got to know each other, and they began to be like an uncle and a nephew. On February 27th, police questioned Brendan at his school. This is long after Stephen Avery was charged with Teresa Halbach's murder. And they needed to speak to Brendan because, quite frankly, there were problems with their case against Stephen. What looked like a strong forensic case with all of this evidence was clouded by the fact that the same police department that had railroaded Stephen in the earlier case had been involved in the discovery of almost every piece of significant evidence in the new case involving Teresa Halbach. And they weren't supposed to be. They were supposed to be walled off from that investigation. Yet every time a piece of evidence was discovered, they were present, and in many cases were actually the ones who discovered the key, for example, in Stephen Avery's trailer. So given their history and the fact that they weren't supposed to be involved in collecting evidence, the police were really, and the prosecutors were really worried that Stephen would claim that he was railroaded a second time. And the fact that he had an outstanding lawsuit that was for millions of dollars, that gave these officers some incentive to want to pin this second murder and rape on Stephen Avery. They also didn't have a narrative of what happened to Teresa in her final hours. And they wanted to be able to spin for the jury, a compelling story, a horrific tale of Teresa's final hours. And they knew that of all the people in the Dassey family who was most vulnerable to police pressure, most likely to be able to provide that account because he also was on the property that night and had been with his uncle later in the evening as they burned garbage in their burn pit, was Brendan Dassey. So they interviewed him over a 2-day period, 3-day period. They interviewed him 4 times. They questioned him at his school. And at the end of that interrogation, he admitted being at a bonfire with his uncle on October 31st. And he also admitted seeing parts of a human body in the fire. He also admitted helping his uncle clean up some reddish-brown motor oil on the floor of the garage. They then took him away from the property and put him and his mom and up on at a local resort in a hotel room and questioned him a second time. And then 2 days later, on March 1st, they brought him back for questioning at a faraway police station where they could record the interrogation in its entirety. And over the next 3 hours, police officers got a more detailed confession in which he admitted to not only witnessing his uncle killing and raping Teresa, but participating in it. He was charged with sexual assault and murder, convicted and sentenced to life with parole in 2048. Now, the first time he was questioned was at school, just like many of you are in school. Police officers came to the school and they arranged with the principal to take Brendan out of class and bring him to a room in the school where they questioned him on audio. It was only a tape recorder in that room about Teresa's disappearance and her final hours. And we have a tape of that. And then the most important interrogation, if you will, is the one that took place on March 1st, 2006. Now, between February 27th and March 1st, the police officers learned something, a fact in this case, that they didn't know before, and that they knew that if they could get Brendan to admit to seeing this or witnessing this, that they would have a pretty strong case against Brendan and Stephen. And that fact was that Teresa Hallback had been shot in the head. They were able to discover parts of Teresa's skull and to discover that there was beveling, a process that occurs when a bullet strikes the skull and leaves traces of lead in the skull. So they needed Brendan to say that he saw Teresa be shot in the head. Now, from the very beginning in this case, the police officers used the threat of being charged to get Brendan to talk, and they contrasted that with promises of help. Let's see a little bit of that.
And we've got people back at the sheriff's department, district attorney's office, that are looking at this now saying, there's no way that Brendan Dassey is out there and they see something. And they're talking about trying to link Brendan Dassey with this event. Not saying that Brendan did it, but saying Brendan had something to do with it or cover up of it, which would mean Brendan Dassey could potentially be facing charges for that. We've gotten a lot of information. Some people don't care. Some people back there are saying, well, we'll just charge him. Say, no, let us talk about this. You have the opportunity to come forward with information that you have, get it off of his chest. Make it look, you can make it look hard if you want.
We want to go back and tell people that, Brendan told us what he knew. We want to be able to tell people that Brendan was honest. He's not like Steve. He's honest. He's a good guy. He's going to go places in this life. But in order for us to do that, you need to be honest with us. And so far, you're not being 100% honest.
Mark and I both want to go back to the district attorney and say, you didn't do it. Yes, he was very straightforward, finally told us. Imagine how it was weighing on him. We'll understand that.
We'll go to bat for you. But you have to be honest with us.
Because Mark and I looked at the tapes, looked at the notes, and it's real obvious there's some places where some things were left out or maybe changed just a bit to maybe looking at yourself to protect yourself a little. From what I'm seeing, even if I fill those in, I'm thinking you're all right. Okay, you don't have to worry about things. We're there for you. And we know what Stephen did, and we know kind of what happened to you and what he did. We just need to hear the whole story from you. As soon as we get that, we're comfortable with that, I think you're going to be a lot more comfortable with that. It's going to be a lot easier on you down the road if this goes to trial and stuff like that.
Honesty here, Brendan, is the thing that's going to help you. Okay, no matter what you did, we can work through that. Okay, we can't make any promises, but we'll stand behind you no matter what you did. Okay, because you're being the good guy here. You're the one that's saying, you know what, maybe I made some mistakes, but here's what I did. The other guy involved in this doesn't want to help himself. All he wants to do is blame everybody else. Okay, and by you talking with us, it's helping you. Okay. Because the honest person is the one that's going to get a better deal out of everything. You know how that works. Mm-hmm. You know, honesty is the only thing that'll set you free.
Honesty. It's the only thing that will set you free. But in order for Brendan to be honest, he has to say exactly what the police officers want and need him to say. And he has great difficulty doing that, at least without help from the detectives, at least without contamination of his interrogation by these detectives. You see the threat. We have the district attorney over there. He's ready to pull the trigger on charges against you, Brendan, but we're going to hold him off. Okay? We're here to help you. We're going to help you, Brendan, but we can only do it if you tell us what you want to, what we want you to tell us, what we need to hear. Now, there are a number of different ways that police officers lie to suspects. They can be very specific or they can be general. And one of the most general kinds of false evidence ploy is what's known as the omniscience ploy. The cops are all knowing. They have all the information they need, and it all points at you. They already know what happened. They just need you to confirm it. Or if you don't, they don't really even need you to confirm it because they already know what happened. And over again, during Brendan's interrogation, these three words were said: we already know. And the truth is, they had no idea what happened to Teresa Halbach.
And we know, like Tom said, we reviewed those tapes. We know there's some things you left out. And we know there's some things that maybe weren't quite correct that you told us, okay? We've been investigating this a long time. We pretty much know everything. That's why we're talking to you again today. Why did he have you come over there? Did he need help with something? Remember, we already know, but we need to hear it from you. Why did he have you come over there? Brandon, were you there when this happened?
No.
Okay. Was she dead there then or not?
Yeah.
How do you know that? I have a feeling I know how you know that.
We already know, Brandon. We already know. Come on, be honest with us. Be honest with us. We already know. It's okay. We're going to help you through this, all right? Oh, come on, be honest. You went back into that room.
Don't let us down, Brendan.
We know you were back there. Let's get it all out today. This will be all over with. Brendan, be honest. You were there when she died. We know that. Don't start lying now. We know you were there. What happened?
We already know. You know, police officers don't have to yell and scream and shout and bang their chests and bang tables and point fingers. With a suspect like Brendan, that would have caused him to shut down completely. They sweet talked him. They played the role of police officers who were concerned with his well-being. They played the role of parents or fathers not cops. And they took advantage of the fact that Brendan's mother wasn't there by lying to him about what Brendan's mother supposedly told the police officers, that she urged him to cooperate and that she told them that he would be honest. But look about this role confusion. Police officers are not allowed to tell a suspect that they're not acting as cops during the course of an interrogation. That is the kind of role confusion that is likely to cause a suspect like Brendan, who already has a hard time understanding his situation, to be even more overwhelmed. Listen to this.
Mark and I, yeah, we're cops. We're investigators and stuff like that, but I'm not right now. My father has a kid your age too. You got more. That's why I got more to come over and give you a hug and then overheard. Talk about it. Maybe high and dry. We'll talk to your mom after this. And we'll deal with it. Best we can. For your good, okay? I promise I will not let you high and dry. Stand behind you.
We both go, Brett. We're here to help you.
Your mom said you'd be honest with us.
And she's behind you 100% no matter what happens
Yeah,
here.
that's what she said, because she thinks you know more too.
We're in your corner.
We already know what happened. Now tell us exactly. Don't lie.
We're in your corner. We'll go to bat for you, Brendan. We'll stand behind you. We won't leave you hanging high and dry. Over and over again, these officers said things like that to Brendan. Yeah, they're in his corner. They're in his corner while they watch him get locked up and sent away for the good part of the rest of his life. They'll stand behind him as he gets taken out of the courtroom and sent to the Department of Corrections. These kinds of lies are part of the process of inducing Brendan to confess. Now, again, they get Brendan to make some admissions, and even those admissions are contaminated. When Brendan says he saw toes in the fire, it was after the police officer said, "Did you see a foot in the fire? Did you see fingers in the fire?" It was after they said, "Did you see a hand in the fire?" So they're leading Brendan even to those earlier admissions. But the worst contamination in the case comes with respect to three things. One is the fact that Teresa was shot. Brendan can't come up with that answer. And he is coming up with scenario after scenario, and it's clear he's trying to please his interrogators, but he has no idea how Teresa was killed. The other thing is, where did Teresa's belongings end up? Well, they found her cell phone, her camera, and her purse in a burn barrel. But Brendan couldn't lead them there. The interrogators fed that fact to him. And finally, they needed Brendan to say that he was there when Stephen lifted up the hood because they found Stephen's DNA on that hood latch. And see how they got him to say he saw Stephen lift up the hood. And ask yourself, whose confession is this? Is this Brendan's confession, or is this the police officer's confession?
What else?
He tied her up.
We know he did something else to her. What else did he do to her?
He choked her.
What else did he do to her? We know something else was done. Tell us. Or what else did you do? Come on. Something with the head. Brendan?
Yeah.
What else did you guys do? Come on.
What he made you do, Brendan, we know he made you do something else.
What was it? What was it?
We have the evidence, Brendan. We just need you to be honest with us.
That he cut off her hair.
Okay, what else?
What else was done to her head?
That he punched her.
What else? What else?
He made you do something to her, didn't he? So he would feel better about not being the only person, right? Yeah.
Mm-hmm.
What did he make you do to her?
What did he make you do, Brendan? It's okay. What did he make you do?
Cut her
Cut her where?
on her throat.
What else happens to her in her head?
Extremely, extremely important you tell us this. For us to believe you.
Come on, Brendan. What else?
We know, we just need you to tell us.
That's all I can remember.
All right, I'm just going to come out and ask you. Who shot her in the head?
He did.
Why didn't you tell us that?
Because I couldn't think of it.
Because I
Okay,
couldn't.
what else?
Because I couldn't think of it. If you witnessed someone being shot in the head with a .22 caliber rifle at close range, if you were there and you saw that, that would be the first thing that you told investigators. That wouldn't be something you couldn't think of. And Brendan did not witness that. He did not see that happen. He was led there by officers. In fact, I don't know whether any of these other things happened to Teresa Hallback. There's no evidence of any of these other things. There's no blood, there's no hair, there's no DNA linking Brendan to the car, the trailer, the garage, or any of the crime scenes in this case. And believe you me, Brendan, is not the kind of kid who's going to commit the perfect crime and to clean up everything that has his DNA on it, while at the same time, leaving Stephen's blood and Stephen's DNA on significant pieces of items. It's not, doesn't make sense. And the way the police officers question Brendan is, to me, highly coercive. And his confession that he ultimately gives is highly unreliable. It is more parts police officer than it is Brendan's confession. And I'm not going to play them for you, but he does the same thing with the hood and the same thing with her cell phone purse and her camera. He is led into giving them the answers. It makes his confession seem credible, but when you slow down the action and watch the interrogations and see the lack of corroboration of what Brendan says, you get the sense that this confession is unreliable. And that brings us to the saddest part of this case, the part that breaks my heart every time I watch this video, is what happens after the confession. You saw what happened when his mom came in, but there are two things that happened before that that just show you how at sea Brendan is, how so under the power of these interrogators was, how he so thought they were there to help him, that he actually thought he was going to be able to leave that interrogation room and go home, or excuse me, go to school after confessing to what he confessed to.
Am I gonna be at school before school ends?
Probably not. I mean, we're at 2:30 already, and school's over at what, 3?
3:05.
3:05, yeah. No.
What time will this be done?
Well, we're pretty much done. You know, we may have a couple of follow-up things to ask you, but it's pretty much done. You do understand that you're under arrest now?
So could I call my girlfriend and tell her that I couldn't come today?
We'll give you an opportunity to do that. Okay? Did you kind of, I mean, honestly, after telling us what you told us, you kind of figured this was coming? Yeah?
This is only for one day, or where am I going?
Where do you think you're going?
I don't know.
You're going to juvie. That's where you're going. To a juvie jail. About 45 minutes away.
Yeah, but I got a question.
What's that?
What would happen if he says something, like his story is different, but he says he admits to doing it?
What do you mean?
Like, if his story's like different, like I never did nothing or something.
Did you? Huh?
Not really.
What do you mean, not really?
They got to my head.
Huh?
I'm saying it to you.
So Brendan's mother, Barb, is struggling with what Brendan means when he says they got to your head, and that he didn't really do anything to Teresa. And so she's trying to figure out what Brendan means, and then it finally dawns on her. And this is someone who knows her son better than anybody else in the world. What Brendan is trying to tell her, is that he was pressured into confessing.
What do you mean by that? What do you mean by that, Brendan? Were you pressuring him?
Who are you talking about?
Him.
What do you mean pressuring him?
When talking to him.
No, we told him we needed to know the truth. We've been doing this job a long time, Barb, and we can tell when people aren't telling the truth. And in my opinion, he'd never be able to live with himself if he didn't tell somebody. There's no way he could live with that. Nobody could live with that. And I think Brendan knows that.
So as anyone of you who have seen Making a Murderer, particularly season 2, knows, is that, we fought like We fought hard in state courts and then in federal court to get Brendan's confession thrown out and his conviction overturned. And we got 4 federal judges ultimately to agree with us that both that his confession was coerced because of the tactics that they used and the way those tactics landed on this vulnerable 16-year-old boy, and that his confession was unreliable because virtually every single fact in his confession was either available, in the public domain because of all the newspaper coverage and leaks to the press about this case, or because of fact feeding by these police officers. And ultimately, we lost by 1 vote in the 7th Circuit Court of Appeals here in Chicago, 4-3. And the Supreme Court of the United States refused to take the case. We had hoped that this was going to be the case where the Supreme Court finally recognized that what it's been saying about teenagers and interrogations since 1948, what it said again in 2011 was true. That when you question children as if they are adults, you run the risk of getting coerced and false confessions. That coercion means something different when these tactics are applied to children than it does with adults. And that there are ways you can tell that confessions are reliable or unreliable. And Brendan's is like a recipe for a false confession. But ultimately, the Supreme Court refused to take the case. And so, as Brendan's lawyers, we're going to continue to fight for him. We're going to continue to do whatever we can to get the courts to take the Supreme Court of the United States at its word and start treating the interrogations of children differently than they treat the interrogations of adults. But there are a few other things that we're working hard on. And that some of these things have come about because of Brendan Dassey's case. Electronic recording of interrogations is so important. Right now, it's actually, I got to correct this, it's actually 25 states plus the District of Columbia, not 28 states. So we're just around the halfway point. Wisconsin is one of the states that records. Illinois is one of the states that record. But in jurisdictions all over this country, they still are not recording interrogations. And there's no excuse not to do it because it gives you an objective, accurate account of what happened in that interrogation room. And otherwise, it's left to the biased perspectives of police officers and of suspects who are going to remember things differently and with oftentimes inaccurately. 2 things that have happened that are exciting to me, which is a recognition that teenagers are much more vulnerable in the interrogation room. There was no parent present with Brendan during this interrogation, but parents often do more harm than good. I've seen multiple cases where they are easily co-opted by police into pressuring their own kids to confess to crimes they didn't commit. The real solution is to give legal counsel to children before they are interrogated, or at least allow them to consult with a lawyer so that they understand that they're giving up something precious when they give up their Miranda rights. And they understand what they're likely to face in terms of coercion from police officers if they agree to speak to police. 2 states, Illinois and California, have now passed laws that require lawyers for kids before the interrogation takes place. And I'm hopeful that other states will soon come online. We need new rules that require prosecutors to show that these confessions are reliable before we allow them to get to the jury. And this can be easily done. They just need to be able to show corroboration of the confessions. And false confessions will be easy to separate from true confessions because none of the corroboration will be there. The suspect will not be able to give the information that only the true perpetrator knows unless he is fed that information by cops. You know, we need, truthfully, what we really need is we need judges to have the courage and to use common sense when evaluating juvenile confessions. It's not an easy thing to throw out a confession, but it's not a question of easy or difficult. It shouldn't matter, whether you're concerned about being elected in the next election cycle because you're too soft on crime. You have a job, and the job is to apply the Constitution and the laws of your state and the United States. And if you do that, in many of these cases involving children, if you look to the words of the US Supreme Court, you have more than enough authority to hold police officers accountable when they do to Brendan what they do to other kids. We need to educate the juries and the public about false confessions. And my colleague Laura Nyrider and I are doing that on a regular basis. We have a podcast, the Wrongful Convictions, False Confessions podcast, where we tell these stories over and over again, just to educate the public that people do confess to crimes they didn't commit. And it happens much more frequently than you would ever imagine. And we need to stop deception. We need to ban police officers from being able to lie to suspects, especially children. Jurisdictions in Europe, the UK in particular, no longer allows deception to be used because they know that it is the first step down the road to a false confession. And they have not suffered any loss of confessions because they no longer are allowed to lie to suspects. It's just made them better police officers. It's made them work harder to get corroborating evidence so that these confessions don't stand alone. It's made them investigate their cases and to use evidence as the basis for interrogations and not false evidence ploys. We need to do that in the United States. If we're ever going to get rid of false confessions, and if we're ever going to get rid of false and coerced confessions of juveniles, these are some simple steps that need to be followed. Thank you.